in Hoke.
This week, a judge ruled that the man charged with killing Maurice Stallings and Vicki Lee Jones at the Jeffersontown Kroger last year does not presently have the mental competence to stand trial. That ruling comes in the state case against Gregory Bush. He's also charged with federal hate crimes over the alleged racial motivation behind the killings. We're taking a closer look at this case tonight. Attorney Leland Hulbert is a defense attorney but has put in many years as a prosecutor. And thanks for joining us. The first question on my mind is that under Kentucky law, what does it take for someone to actually be competent to stand trial?
Basically, competency surrounds the issue of being able to assist in your own defense and understanding the nature of the proceedings against you. So if you can't assist your attorney in preparing a defense, if you can't understand the charges against you, if you can't appreciate the process and what you're facing, then you can be found incompetent to stand trial. So
if someone is found competent, they can still pursue an insanity defense in the trial? That's true. In the case at hand, a person was found incompetent but likely to regain by the judge. And you could be found directly incompetent, and if there's no likelihood of regaining, it has to go one direction and cannot be a trial. You cannot be tried if you're found incompetent. But if you're found incompetent but likely to regain, as in this case, then there's more evaluations, more determinations, medication is used, and then a final evaluation by the court, either in 60 days or in a period longer if necessary, if there is actual hope that a person will regain or become competent. In your observations about this case and past experience that you've had, what do you think is the likely path we'll see here? I have had a situation where a person received treatment and became competent. And I think that is more likely to happen in this case. I don't know all of the medical facts surrounding what the psychiatrist found, but I think right now, if I had to guess, I think they're going to err on the side of finding him competent at some point, but there is a possibility they may not. Do the federal courts have a different standard for competency? The federal courts will likely wait and see what happens in the state court to see how that progresses, and then their case will be handled with the hate crime element of this afterwards. So the state case could affect what happens in federal court? I think it could, yes. What do you see happening here? I think that in this case, again, there's so many levels of mental illness or mental issues that this defendant or any other defendant, I mean, what he's charged with doing and his allegations are horrific, and only a doctor is going to know exactly what his ability is to help his attorney. So an attorney doesn't really have a say in this competency process once it's turned over to a doctor. The doctor is picked by the court and reports directly to the court, and then once that report is completed, it's examined by all counsel and the judge. There'll be another competency hearing in probably July or within 10 days after that if there's a final determination, and then we will all know will there be a trial or will he be found incompetent. And again, we're just getting started in this. Very, very interesting so far. Leland, thank you very much. You're welcome. And here's what's coming up. Dawn?
Well, still to come, local students learning how